Our next speaker is Dr. Marcus Goffe, who will speak on access to genetic resources and associated in the Caribbean. And I ask that not to repeat any of the information that has gone before, but to give us a more focus on the CARICOM context. Dr. Marcus Goffe is an attorney at law and legal consultant with over 20 years of experience in several areas, including intellectual property law. Dr. Goffe, PhD research focused on the protection of intellectual property, traditional knowledge, and traditional cultural expressions in the Caribbean community. He's also responsible for drafting the draft regional framework for protection of GRs, TK, and TCEs in the Caribbean. He's also a former deputy director and legal counsel for the Jamaica Intellectual Property Office. Dr. Goffe?
Okay, thank you. Thanks, Wendy, and thanks to everyone. Good morning, everyone, or good afternoon, good evening, wherever you are. I'll try to take you through quickly. It's been a very interesting morning. So I'll be looking briefly at, well, I'll be skipping out some of what has already been said already. And as I say, really just trying to focus on the regional context that we have at present in the region, and also the draft regional framework. So looking at, what is TK and what are TCEs, I won't go into that, as I think it's been discussed quite amply this morning. But of course, at the WIPO level, WIPO has maintained a distinction between TK and TCEs, TK more being on the industrial property side or more akin to industrial property, and TCEs more akin to copyright. So in that respect, then the tracks of research and of engagement have been along those lines. So I'll be focusing really today on TK, looking at primarily in the GR context, and of course associated TK compared with GRs. So yes, I'll talk about TCs perhaps in the future. So in the region, we're looking at different kinds of circumstances, and of course we've heard a bit about different experiences from the communities, right? And so we're talking about in the region, different communities who have maintained different traditions over some time, and primarily in the context of genetic resources, how to use the earth, how to use the plants, how to use certain agricultural and environmental practices and timings and seasons and all of that to be able to develop, unique or indigenous livelihoods that, of course, need to be maintained. Some of the problems we've seen with, this issue, as have also been expressed this morning, are that there's a lack of appreciation, and of course also the unauthorized commercial exploitation of TK by non-TK holders, of course with inadequate or no benefit sharing with the communities, and of course oftentimes involving registration of IP rights over TK or TK derivatives. And so that's been really the impetus that has led to the push globally to find solutions, of course, and led by WIPO and the WIPO IGC in that regard. So in terms of core principles that we've gleaned over the many years of this, it really is focusing on being able to provide respect and recognition to TK and TK holders, respect customary use, and importantly, to appreciate the importance of free, prior, and informed consent, full and effective participation, and fair and equitable benefit sharing on mutually agreed terms. And so this has been really, I think, the core out of which we have seen evolve several national and regional frameworks, and of course, the current international framework being worked on at WIPO. So within this region, the doctor mentioned the revised Treaty of Chaguaramas, of course, within which CARICOM functions and CARICOM member states. And so that has really been a driving force, in terms of the region trying to find solutions to the protection of TK and folklore, and certainly to protect the historical rights and the way of life of indigenous peoples also. And so that's the backdrop within which there were a series of fact-finding missions by WIPO in the Caribbean in 1999 and 2006. CARICOM ministers for IP engaged WIPO to develop this regional GRTK framework, out of which the Caribbean TK working group was developed in 2008, as was mentioned also by Lulu Claire. And out of that, consultations done throughout the region to kind of get the feel for what are the needs and aspirations of the communities and of the national governments, and to be able to have the framework be based on that consultation. So the regional framework has as policy objectives to protect the rights of indigenous and local communities over their GRs, TK, and TCEs, the rights of states over their GRs, and the TK and TCEs which are not attributable would also be in the framework administered by states. And so the objective really is to facilitate commercialization and innovation involving TK, and of course to ensure that the benefits, right, as we saw with the Yapuna video from WIPO, can be shared with those source communities. The regional framework has drawn upon several international frameworks, of course the CBD and the Nagoya Protocol being the primary ones, as well as the UN Declaration on the Rights of Indigenous Peoples, and the WIPO IGC documents, which have evolved, of course, and are still being worked on, which we look forward to the successful conclusion of those processes. There are also several regional frameworks which informed our Caribbean draft regional framework, which we've been able to learn a lot from the region, from the Andean community, from the African Union, as well as from the Pacific countries, as well as, of course, the most recent being out of the ARIPO organization, the Swakopmund Protocol on Protection of TK and Expression of Folklore. So there's a lot of work being done and has been done before. Of course, even within the region nationally, we know that there are ABS frameworks and policies and laws being developed as we speak out of Guyana, certainly, and Dominica as well. And ABS laws really throughout the region and other parts of the world as well have informed the draft Caribbean Regional Framework. So as was mentioned by Wendy, I was asked to draft this framework in around 2013. And that framework really represents a new regime for the protection of GR, TK, and TCEs, consistent with international law, best practices, and WIPO draft articles. And so really is a sui generis model that is proposed for the region to protect TK. It's an integrated framework, and so it's seeking to have the same ABS approach applied to GRs, TK, and TCEs, so that again, the FPIC and the benefit sharing would be able to be paid over or to benefit communities across the board, whether it be from TK or TCEs and GRs, and certainly that it would recognize, as I said, the rights of TK holders or TK owners, and also clarify procedures to access GRs, TK, and TCEs in Caribbean member states. The framework would require the free prior informed consent of the state and or of the communities involved for mutually agreed terms to access these resources. It also seeks to ensure that there's full and effective participation in all decisions concerning GRs, TK, and TCEs to ensure that the indigenous peoples and local communities continued involvement in conservation, in good environmental practices, and that kind of thing is assured, while of course research and development is done. It also ensures, as I say, that there's fair and equitable benefit sharing consistent with the CBD and the Nagoya Protocol. And so it's really a basis for Caribbean countries to be able to have their own national law developed, or of course, or I would say a regional approach, which could be applicable to CARICOM, to CARIFOR, and of course also to the OECS. Within the draft proposed framework, access and use to GR, TK, and TCEs in the traditional and customary context would be exempt, so that would be able to stay within the remit of the communities. And that would be governed by the community's own customary laws. But then outside of that traditional context, you'd have to comply with the ABS framework that's in the model law. So in terms of discovery or biodiscovery or bioprospecting, as it's called also, that would also be governed by the framework. So you have to have transparency and apply for the relevant permits at the national authorization, national entities, sorry, to be able to then have them grant legal access once they have, of course, ensured that these safeguards are met. So the framework has some key provisions, which I want to go through quickly. And these really focus on having the communities, sorry, as the primary beneficiaries. And then outside of that, the individuals who are from the communities or outside of the communities also would have to work within the customary laws or the relevant IP laws that would also govern their contributions to that creativity. State rights over nationally owned GRs would be also recognized, as well as over national TK or where the TK is not attributable to any indigenous people or local community. It would be within the state's authority to maintain and protect and promote. And then within the IP framework, again, following the WIPO model, the draft regional model law has exclusive rights for the beneficiaries, including economic and moral rights, the right to challenge or to oppose IP applications or registrations that use, utilize, concern, involve, or otherwise rely on GR, TK, or TCEs as a means to empower, again, the communities and, of course, national competent authorities to be able to challenge and to use the law once in place to be able to protect TK and TCEs and GRs effectively. The term of protection in the proposed framework would be as long as the resource, knowledge, or expression fulfills the criteria of eligibility for protection. It would be protection would be unlimited in those contexts for sacred TK and TCEs as well. So it's really more in that context like the GIs that would have a kind of indefinite protection so long as the resource continues to be created and used. There would be no formalities, registration. I mean, there may be some forms to fill out and so forth, but there would be certainly no requirement or formalities that would be mandatory. And in terms of exceptions and limitations, there would not be any that would be applicable to moral rights or to secret or sacred TK and TCEs, again, to respect and preserve the community's interests in those areas. So again, it follows the IP models and structures, but now with the ABS embedded in it, which we have taken from the GR's landscape. This is from the CBD and the Nagoya context to apply it in this IP-based framework. So persons who want to get access again within the customary landscape would have to go through the relevant community, or if there's none, then through the state. And outside of the customary context, then we have to have an ABS contract in place, right? To ensure again that there's full transparency, there's discharge of the FPIC responsibilities of the applicant. Of course, there's also compliance with the benefit sharing obligations of the applicant and so forth. Before then, there would be the ability to use or to register an IP involving these TK or TCEs. So the person who wants to register, the IP would have to submit an application to the competent national authority, and that authority would then be a checkpoint, as was mentioned under Nagoya, to ensure compliance with the legal requirements for access and benefit sharing. Mandatory disclosure is also proposed in the framework, which would require applicants to disclose if their IP applications contain, utilize, use, or otherwise rely on any GRs, TK, or TCEs. And I'll talk a bit about that just now before I conclude. And also the maintaining of registers or databases of TK would be encouraged but not be compulsory. Of course, would also involve the FPIC and the participation of the relevant communities. There's also been, through the research, I recognize need to have some assistance for communities to be able to negotiate contracts if they need that kind of support and so forth. So there would be the provision of government assistance in that regard to ensure that the communities also have effective checkpoints at their location in their spaces. Shared TK, which is also very common throughout the whole Caribbean region, particularly in or concerning GRs, as well as, of course, GRs themselves, right? Those issues of joint ownership or joint benefit would be resolved through mediation in the first instance, and if not, with access to the CCJ to resolve these inter or intra-regional disputes. So concerning mandatory disclosure, that would be then required of the applicant, right? They would have to disclose the relevant GR, TK, and or TCEs, any other written or oral information concerning the resource or any derivatives or byproducts, the country of origin, a certificate of origin, country of source, the resource provider, whether individual and or community, and the details of the resource owner and or holder. So again, there can be some monitoring as required by Nagoya to ensure compliance with all of the new legal standards. The applicant would be required also to certify that they have obtained the consent of the relevant TK holders, and they would be required to prove, to provide some proof, right, of consent and of mutually agreed terms through, of course, a concluded ABS contract. That would be the most effective way to do that. If the applicant fails to comply with these obligations or provides false or fraudulent information, then the application may be refused and an IPR may be refused or revoked, invalidated, or otherwise rendered unenforceable. This is really a proposed framework, and again, to have the IP system be more responsive to play its role in protecting GRs, TK, and TCEs, and essentially, to stop or halt or to reduce significantly the misappropriation of TK and TCEs by persons outside of the relevant state, outside of the relevant community. So the draft regional framework was completed in 2014. It was submitted to the CARICOM Secretariat in around 2015, and I think to quoted in 2016, and has not yet been approved at that level. And so we are still awaiting the approval from CARICOM to be able to have it, I guess, implemented regionally, and of course to have it in place to protect the resources in the region. Now, while we wait on, of course, the regional processes, right, and the international processes at WIPO, we also have options at the community level, right, and the national level to protect TK as well and TCEs. And so we can, in our member states, each do, what we can to be able to empower the communities, to also have them be prepared. Oftentimes we have persons from outside of the area or the country coming into these communities to take plans, take resources, to film, document, interview persons, and oftentimes there are no effective measures at these communities to be able to stop these practices. So we can empower the communities to do more to safeguard their own resources. And nationally, we can also seek to amend existing IP laws, right, to prohibit TK registration and to require the disclosure of origin, but also, of course, to mandate fair and equitable benefit sharing, and also to have, if possible, a sui generis law in the national legal system that can protect TK and TCEs, even while, as I said, the regional framework is being discussed and worked through. So just to conclude, I think that in terms of where we are now in the region, there is fertile ground for us to have more sui generis GR-TK laws that are passed and implemented, right, which have ABS policies embedded in them, to be able to, again, have some protection nationally, as I say, while the regional and the WIPO processes move forward. We also, of course, need to, I think, accelerate the regional processes, including the draft regional framework, to ensure regional protection for these resources and to ensure we have the benefit sharing protocols in place as soon as possible to avoid, again, the different countries in the region, being utilized and being played off against each other, so people can still go around or circumvent the system. So the more we're on the same page as a region, the more we can have, I think, a protective framework in the Caribbean for our relevant communities and for their TKGRs and TCEs. So that's it. I hope I didn't take too long, but look forward to all of the discussions. And of course, I also see Mr. Spence is here too. So I know if any updates are there from the region, we can perhaps mention that as well. Thank you.